Well, good afternoon and welcome everybody to today's Financial Services Club webinar. It's on financial services and UK competition law. My name is Robert Pay. I'm an associate at CN, and it's my pleasure to be able to chair this event today. But I can only do so thanks to the generosity of our sponsors, who allow us to range freely and widely across technology, economics, and finance. My job is to get out of the way as quickly as possible and hand over to our speaker, but a few housekeeping notes. The slides are available to download in chat, and they'll be on the website too. After Saskia's 20-minute presentation, we'll be having a 20-minute Q&A session, so please make sure to go to the GoToWebinar chat facility so that you can send your questions through to me, which I will then feed into the conversation. So I'm just about to hand over to Saskia, who's going to talk about how financial services business models should be adapting to UK competition law. And to start off, I know that we're going to start with 3 binary polls. So in true FS Club fashion, fingers ready to be on the buzzers, please. Saskia, over to you.
Well, thank you very much indeed, Robert. Good afternoon, everyone. I'm really delighted to be here with you today from a very windy Kent. But before I launch into my presentation, as Robert said, let's do 3 really quick and simple polls just to see what your general feeling is about competition law and financial services. So let's start with the first question. So do you think the competition authorities understand the financial services sector? It's just a simple yes or no.
And we're normally pretty fast. I can see that the polls are coming through and they're looking pretty decisive already.
Okay. No, very interesting. So let's move on to the next question. Do you think competition law is relevant to what you do? And again, just yes or no.
And again, yes, we have a pretty binary split in the results here, as I can see.
Okay. And are you, oh, sorry, and let's move on to the next question is, are you currently thinking about competition law issues? And again, just yes or no.
This poll looks a little bit closer.
Ah. So no, 53%. Okay, well that's incredibly interesting actually. Let's see how you feel after my session and whether I have any impact on your feelings at the moment. So before I go through the agenda, I'm just going to start with a quick introduction about me. So I'm Saskia King. I'm a legal director in Bird & Bird's competition and EU team in London. And I joined Bird & Bird from the payment systems regulator, where I led its first cartel investigation in the payment space. Prior to that, I was at the Competition and Markets Authority, where I worked on a variety of different matters, including mergers and competition investigations, cartels, and policy initiatives. So my most recent background and specialism is then in competition enforcement. I've also spent quite a lot of time in academia, and I've written extensively on competition law issues. And then in what feels like a previous life, I started my legal career in private practice at an international law firm in the city, where I practiced competition law and corporate finance. So having worked most recently at the PSR, I also dealt with the Financial Conduct Authority quite a lot, as technically the PSR is a subsidiary of the SCA, and we also shared offices. So I have a lot of experience dealing with the intersection between financial services and competition law, and have seen firsthand how financial institutions and businesses approach competition law issues. And I'm afraid to say that there's a lot that really needs changing, as often competition law is not even on the radar of many financial services businesses. So actually this poll is pretty encouraging. And I've witnessed firsthand the sort of the whites in the eyes of directors who are clearly completely blindsided by being under investigation, as they have no real concept of the law. And this is particularly worrying given the number of forums and the amount of networking that goes on in this industry. So to that end, I'm going to be speaking to you about 4 key topics at a very high level. So I'm going to start with why, if you're not already thinking about competition law, it's something to urgently have on your radar, as it affects everyone, no matter how small your business is. I will then walk through a few of the key developments in tech innovation, which have influenced the financial sector and raised competition law issues. Then the rest of my presentation will focus on data and collaboration or partnering. And just to note, all the issues discussed apply pretty much equally across the EU and UK for now, though this is possibly something we can touch at the end of my presentation. So if we can move on to the next slide, please. So who's watching you? So unlike other sectors, companies operating in financial services, particularly those operating in the payments space, are under the watchful eye of potentially 3 competition authorities in the UK, and that is the CMA, the PSR and the FCA, and each of which has the same competition law powers, as well as its own priorities and focus, and more importantly, they all communicate with one another. And the significance of this is that where one may not be interested in opening a case following a complaint or a leniency application, another might. And so the CMA and FCA have also been quite open about the fact that they will be opening new cases in the financial services space. That said, nothing has yet been announced, and so far there have been no further updates. But I do not believe that necessarily implies businesses can be more agnostic towards UK competition authorities. If anything, the move towards closer collaboration between the competition agencies means businesses need to be on guard when dealing with the authorities and consider carefully how any information they provide may be shared and used by other authorities. So the close collaboration between authorities in the UK is also evidenced by the formation of the Digital Regulation Cooperation Forum. And it currently comprises of the CMA, Ofcom, the Information Commissioner's Office and the FCA. And the forum was established to ensure a greater level of cooperation between the authorities, given the unique challenges posed by regulation of online platforms. And the forum's constitution highlights the close interaction between the various disciplines of financial services, competition law, data protection and data access issues. And certainly the fast pace in the evolution of financial services through the use of, for example, digital tech over the years has not, in my view, necessarily meant that the competition authorities are behind the curve. The CMA's market study on online platforms and digital advertising contained really useful insights into how the CMA approaches access to data, network effects, economies of scale, vertical integration and ecosystems. And the CMA has also opened an investigation into Apple's conduct in relation to the distribution of apps on iOS and iPadOS devices in the UK, and in particular the terms and conditions governing app developers' access to Apple's App Store, including the use of Apple's payment systems by developers. And this is also underpinned by the launch of the CMA's Digital Markets Unit, which focuses on understanding and investigating digital markets, but it does not yet have formal powers. And just also more particularly, Ron Khalifa published a report early last year on the fintech sector, which emphasised how the sector could be supported, or should be supported rather, by the government post-Brexit. And it also pointed a finger at the CMA in terms of how it assesses mergers in fast-growing markets. And it warned the CMA against being too interventionist. So the CMA, which has exclusive jurisdiction over mergers, did not necessarily pay this much heed, given its continued bullish approach to intervening in mergers, but it did listen in respect of how it accounts for evidence in its assessment of mergers in this space. And just to note that given the number of mergers in the payment space in particular, I think the CMA is actually pretty comfortable dealing with these sorts of acquisitions, given its deep dive into tech and digitalization issues. So why do we care about competition law? Well, competition law prohibits firms from engaging in conduct which will distort the competitive process and harm competition by, for example, preventing firms from entering into anti-competitive agreements, preventing firms with a powerful position on the market from abusing their market power or dominant position, and preventing firms from substantially lessening competition by merging with their competitors. And there are serious consequences for infringing the competition rules. Not least, businesses can be fined up to 10% of annual worldwide turnover and thereby also expose themselves to possible damages actions. Also, anti-competitive agreements will be void and unenforceable, and more significantly, individuals could also find themselves facing director disqualification orders for up to 15 years or even criminal prosecution for serious breaches of competition law. And in the UK, there is a particular focus from the authorities on individual liability. So, for example, director disqualification orders. So not just on the liability of the business itself for any competition law infringements. And the focus on individual liability means that company culture and how seriously directors take competition compliance is key. So the CMA, the PSR, the FCA are all actively thinking about director disqualification orders at the outset of any investigations. And so this underlines the importance of a top-down compliance culture in any organization. So any business, whatever its legal status, its size, needs to be aware of competition law, firstly so that it can meet its obligations and in doing so avoid heavy penalties, but also that it can assert its own rights and protect its position in the marketplace. So if we go on to the next slide, please. So turning now to the evolution of business models in financial services, digitalization has, as we know, brought disruption to companies' business models and to market dynamics. In particular, digital banking is fiercely competitive and has led to new and innovative products and services, and indeed partnerships between actual and potential competitors. And tech giants have also entered the space and are providing new services to consumers, leveraging their presence and power in the financial sector. And not least, underpinning the financial sector is a regulatory framework, which too is evolving. And this is exacerbated by the global nature of financial markets. So the financial sector therefore poses a significant challenge to the competition authorities in the UK and the EU, and the authorities consequently have tech and financial services high on their enforcement agendas. So useful analogies and competition issues to look out for can certainly be drawn from developments in big tech. So for example, how firms use and leverage their ecosystems, access to infrastructure and access to data, and more importantly, understanding how the competition authorities approach these issues. And so many antitrust authorities believe the competition rules are simply not sufficient to deal with big tech. And you may be aware that there is a raft of regulatory proposals at both the EU and UK level, encapsulated in the EU's Digital Markets and Services Act and the UK's Strategic Markets Status Regime, designed to tackle big tech head on. But competition law, of course, remains relevant, and there are a plethora of ongoing antitrust investigations dealing with big tech, such as investigations into Apple, Google, and Meta. And so it's really important, I think, to anticipate and monitor how competition authorities may apply the principles they develop in the tech space to financial services and payment institutions. And a good example of this is the CMA's current research into algorithms and AI, and how algorithms and data sets are being used by digital companies to target or discriminate against individuals. And banks' algorithms also came under scrutiny around mortgage approvals, as the effect of algorithms could mean banks and other service providers lock out certain consumers. But also, just on a more vanilla basis, companies operating in financial services continue to get caught out by the competition rules in the UK and the EU. But in the UK, the FCA issued a decision regarding illegal information exchange between asset managers on their bidding intentions during IPOs and placings. And the PSR also recently issued its decision following its 2 cartel investigations into the prepaid markets. And it fined the 5 parties involved a total of £33 million for market sharing by allocating customers between them. And more significantly, in one of the cartels, the parties were operating at different levels of the market, and their participation in a networking forum was key to the development of the cartel. So if we could go on to the next slide, please. So more particularly, the advent of PSD2 or open banking has essentially opened the financial services market and provided new opportunities and the entry of new players and products, especially in the payments space. But tensions exist in that incumbents like to maximize their position in the market, whilst new entrants want to alter the market dynamics. And as such, we see established incumbents working together with startups to develop and incorporate innovative tech, so that incumbents can stay ahead of the competition as markets evolve. But this is, of course, of keen interest to the competition authorities. Though it doesn't now end at open banking, open finance is the next step in the open banking journey and refers to the extension of open banking like data sharing to a wider range of financial products, such as savings, investments, pensions, and insurance. And so this raises both opportunities and benefits to customers, but also risks in terms of data ethics and access to data, and of course, who controls it. So this is neatly, hopefully, leading me into my next topic, which is data access and competition law, which is on the next slide, please. So there's been a lot of debate over data in the competition law space, and heated debate remains over the value of data and questions such as, are we approaching data in the right way? How important is it to categorize data? How valuable really is open data? And what is for certain is that the competition authorities have raised data access, data privacy, and their interaction with competition law as key areas of concern following market studies and investigations, which have also shown the significant value of data to companies, particularly to dominant companies. In fact, the EU Commission describes data as an essential input. And this is primarily because research has shown how data enables companies to be competitive and to foreclose their competitors. So currently, much of the discussion revolves around big tech and how it should be regulated, but the principles raised are also applicable to all data-rich sectors, such as financial services or the financial sector. And in financial services, consumer data obviously plays a key role, particularly with the advent of PSD2, open banking, and the competitiveness of financial or payment services firms will increasingly depend on real-time access to big data sets and the ability to use them to develop innovative products. So the question is whether regulatory intervention is needed to ensure sufficient and timely access to data. And competition law can play an important role here by ensuring that in a proportionate manner that a level playing field is maintained. So for example, when data access is warranted, that access is granted on fair, reasonable and non-discriminatory terms and in a manner that does not enable or facilitate collusion. And in retail banking, one of the data-related concerns or issues rather concerns the perceived asymmetry in supervisory and data portability regulations applicable to big tech as compared to the banks. So big tech entry into retail finance may actually be facilitated by the asymmetric data conditions that are regulated in the market. Banks are obliged under PSD2 to provide access to bank account information, but this access condition does not then apply to fintechs and big tech, so hence an alleged asymmetry. Though symmetric data access may also create risks, as the mandated access under PSD2 is limited and targeted. So Questions on access need to obviously be addressed on a case-by-case basis, particularly when viewing access issues under the lens of abuse of dominance. And pertinent questions will be: what type of data is needed? Can the data be obtained from other sources? Is the request for access proportionate? Is a regulatory approach preferred to competition enforcement, or a mix of both? And several competition authorities have declared that they would seek to use competition law for forcing companies to give third-party access to data collected by them. But enforcing such obligations is quite challenging, of course, particularly where data, or where the data concerned is personal data. So data access will actually also be addressed through the proposed Digital Markets Act in the EU and the development of the strategic market status regime within the UK. But concerns are also created by companies who leverage their market power into niche or unregulated markets, which then become impossible to compete against. And so this may go hand in hand with such companies then refusing access to new technology essential for developing new solutions, and excluding businesses who would otherwise be important competitive constraints. And clearly these issues haven't yet been fully answered, but the authorities, the competition authorities, continue to assess, their current and proposed regulatory tools to deal with these types of practices and new types of practices, and to have them on their own radar. But of course, one way that the competition authorities can constrain behaviour is through an active merger control regime, which leads me onto my final topic of collaboration, and also my final slide on my presentation. So there are, of course, huge amounts of collaboration in this sector, and of course involving tech entities, and much collaboration is perfectly legitimate and pro-competitive. However, it can also tip into something that may raise competition or issues. As such, it's crucial when entering into any collaboration that you understand where the red lines and the warning signs are, so that you can navigate them. And agreements that are more likely to raise competition concerns are those where the parties are competitors and one or more parties has an appreciable, or rather a significant, share of the market. And in every collaboration or partnership, of key concern and risk will be the prospect of the sharing of commercially sensitive information, and therefore for the business to ensure the right parameters are in place to protect against this. And certainly partnerships between competitors always need to be carefully managed, as the exchange of strategic information is a serious competition infringement and still remains high also on the competition authority's agenda. And the Commission has also, like the FCA, issued several decisions in respect of information exchange within financial services, a number of which related to trader chat rooms. So I've also touched very briefly when I first started on the many fora and networks in the financial services sector, which likewise raise competition issues regarding potential information exchange. And not so long ago, the CEO of the CMA highlighted the concern of information specifically within the financial services sector. And he stated, and I paraphrase, "People sitting together means lots of risk. People cross the line and discussions happen that shouldn't." So having proper governance in place to manage participation is crucial. So do staff know where the red flags are? Are they trained on antitrust issues, and do they know what is safe to discuss? And likewise, using fora such as trade associations to set new standards, which is also a hot topic for tech companies, raises competition issues, not least the risk of this spillover into exchanging commercially sensitive information that goes beyond what is necessary for setting the standard. And we know the EU Commission, the CMA and the FCA all generally support innovation, but I mentioned competition concerns where big tech and fintechs enter the market and look to partner with incumbents, plus where larger incumbent companies look to acquire new innovations and integrate them within their ecosystems, or partner with innovative tech companies to create new products which become integral to the sector. As such, there are many concerns about so-called killer acquisitions, and the CMA and the Commission are acutely aware of their historic under-enforcement here. So hence, any acquisitions you make will be under more scrutiny than ever. And this shifting, tougher attitude of the EU Commission and competition authorities more generally to merger control is notable. And post-Brexit, the CMA is more bullish than ever in asserting jurisdiction. So mergers such as the PayPal-Zettel merger demonstrate the CMA's willingness to account for forward-looking evidence as to how markets may evolve in the future and the state of competition, not just the current state of the market. And this has been encapsulated in its new merger assessment guidelines. So to this end, the CMA is particularly keen on reviewing parties' internal documents to understand the pro-competitive rationale of the merger and what the parties think the impact or the effect of it is. So ultimately, what you say in your internal documents, so your board minutes, your presentations, your emails, and your strategy papers, matters, as the CMA can and will request them. And if what you say in a notification is not supported by what is in your internal documents, then that will be problematic. Therefore, it's important to think of how you present your business objectives and desire to improve and better your services for your customers. So not necessarily about how you're looking to annihilate the competition. So a key takeaway is to think about your policies and procedures. Do you have adequate procedures in place, including clear escalation procedures for when staff meet competitors, attend fora, or the business decides it wants to acquire or invest in an exciting startup? And do you know where the red flags are? So I'm going to end my session now. There's obviously a lot to think about in this area, and I've really only scratched the surface. So business models may be evolving, but the competition I think the competition authorities are for once pretty much in the loop. And so I think it's worth giving extra careful consideration to them. So thank you very much for your attention.
Well, thank you very much indeed for that, Saskia. We've got a few questions here for you.
Excellent.
So the first one comes from Bob McDowell, and he's asking a question about whether the UK competition authorities have any remit over UK companies that may be engaged in what may be perceived to be anti-competitive arrangements in jurisdictions where there are no competition regulators.
So the UK authorities will only have jurisdiction in relation to issues concerning the UK, so trade affecting the UK. Right. Is that what the question was?
I was wondering whether that might include sort of, offshore entities where the UK has some involvement, but are you saying
so there has to be impact within the UK itself? So you can have offshore companies which aren't UK entities, but they trade in the UK, or whatever they do has an impact within the UK, and that's where the competition authorities will have jurisdiction.
Okay, I think Bob was actually thinking about UK companies that may be dealing in countries where there are no competition authorities, and you probably think of a lot of offshore centres where that might be the case.
Oh, I see.
Which actually have substantial financial services businesses.
Yeah. I mean, if they don't have their own competition authority, then it could be, that the EU may, well, then again, the EU, it has to be, the jurisdiction depends on if there's an effect on trade between member states, and with the UK, there has to be an impact within the UK. So I think if you kind of apply that test.
Okay. Question here now from Dan Fahey. Thinking about the CMA's OBIE, which is, I think, Open Banking Implementation Entity, were there and are there enough regulatory and legal experts on the team beyond the technical and commercial experts? Very specific.
That's a really good question. Very specific. That's really good. A really good question. I don't know the exact answer to that, but I know from experience that generally the CMA is very keen to ensure there will be experts involved who understand very, very well open banking, the financial system. I mean, certainly when open banking was first devised within the CMA as part of its market investigation, the people who were involved in that are still involved in the initiatives going forward. So they have a very deep understanding of the state of the market and how competition is evolving. So just on my experience, I would expect, but I don't know for certain, but I would expect there would be a number of experts who are involved. And they will certainly be working very closely with the FCA, for example.
Right, thanks a lot. And now a question about data. You talked quite a bit about the important data. Have there been any rulings which actually define a data monopoly? And this is a question from Hugh Purser. And if not, is it even possible to define what a data monopoly might be?
Gosh, that is a good question. I think I might need to understand by data monopoly, we probably are referring to one of the big tech companies that, like Google, which has a huge amount of data. Is that probably what we're referring to? I mean, there's a lot of investigations going on at the moment in relation to data captured by these big tech companies. And what the competition authorities are looking at, certainly the CMA and the EU Commission, is whether by the very nature of these huge data sets they have, the way they utilize them can abuse their dominant position. And so that is basically one of the areas where there's a lot of challenge going on and where the authorities have made decisions in this regard. So it's one of the areas to watch at the moment to see how this develops. But I think certainly the large data sets, and that's what also this regulation is looking to touch upon and to try and control more about how this data is used, these huge data sets that they have access to.
Okay, Jeremy Wilson thanks you very much for your excellent interview, and then asks, do you think that competition authorities will accommodate the need for incremental regulation as the new fintech-enabled financial services models evolve, such as the inclusion of digital currencies and the aligning of new technologies such as AI and the algorithmic disciplines in the provision of new financial services?
Yeah, so I think certainly from a competition perspective, obviously the FCA keeps looking at this because I know it's looking at fintech and AI and cryptocurrencies, and so is the PSR actually as well. And that becomes part of their strategic objectives. So each year they look at their annual plan and they'll include those issues that are coming up in the market. But with the CMA, they will also be on top of these things through the Digital Markets Unit, and also through this regulation that they are hoping will go through Parliament fairly soon in relation to regulating the big tech companies. But certainly, just more generally speaking, you know, putting big tech aside, I think the competition authorities have realised how important it is that they're up to date as far as they can be and are actually hiring the right experts to understand how markets evolve. And the way that the rules are drafted means that there is scope for things, for flexibility, for things to evolve as markets change. And so it is quite dynamic. But also what the CMA has done is that in its guidance, it will update that quite regularly. So for example, in its merger assessment guidelines, it's taken account of the fact that, you know, the digital market works very differently. So it's looking at forward-looking evidence, so not just what the market is now, but how it may evolve. So they have a number of ways, a number of tools in which they can try and make sure that they capture various developments. It may not necessarily be through regulation as such, but certainly through the iteration of guidelines and things like that.
Okay, thanks very much for that. And now another question from Dan Fairney. Given PSD2, how will the TPP data aggregator businesses play out? You know, I was thinking of you know, players like Tink, Plaid, and TrueLayer.
So can you how will the
TPP data aggregator business models play out?
Given PSD2?
Yes.
I might have to think about that one a bit more. I'm not really sure. I mean, I think that PSD2 has given all these sorts of data aggregator business models a lot of scope to think about how they want to develop their businesses. And I think that was the whole point, actually, was to open the system up and allow more players to come in. But I think that said, the competition authorities are also looking at this and how the market is evolving. But the idea really is that, you know, innovation is a good thing, and that they should be able to use the rules to their advantage. And it's not until they become dominant themselves that things might become more problematic.
There is an opportunity for anyone to email Saskia and actually take some of these more complicated and involved questions offline. To finish up, yet another question from Bob McDowell, and this is one that we were chatting about before the session began, is to what extent at all do you see the UK competition regulators collaborating with the EU competition regulators?
Well, they will remain in very close collaboration with one another. The CMA knows how important it is that they are completely plugged in to what the EU Commission does. And so even though they don't have the benefit of being part of the European Competition Network, they're still part of the International Competition Network, and there's also the OECD. So actually, and then they also have various memorandums of understanding between each other as well. So they will be looped in with one another. I mean, certainly the CMA had a lot of influence over how the EU Commission is developing its Digital Markets Act, because the CMA have already done a market study. And so I think between them, they realise it's really important to keep that intel going. And also, it doesn't just end with the European Commission, it's around the world. So with the US competition authorities, Australian competition authorities, there's still a lot of collaboration, and that's the way it's going to keep going.
Thanks very much indeed for that. And we've actually come to the end of our questions, and so therefore towards the end of our time together. What I'd like to do before we finish is to thank again all the FS Club sponsors who make these events possible. And my goodness, we've got a very busy week this week. We've got 3 more seminars coming up. Tomorrow on security, forward risk and intelligence. Wednesday, the new political capitalism, which I think touches on some of the things we talked about today with technology companies in particular playing quite a big role in politics. And then looking at renewable energy and the internet on Thursday. So there's 3 great events there for your diaries. And finally, a big virtual round of applause for Dr. Saskia King of Bird & Bird. And thank you very much, everybody. We'll see you again here soon.
Thank you.